Thank you so much for joining us today. First question, I just want to know, what does this bill do?
It's really simple. The concept of this bill, technically it does two things. It takes the word mandatory out of these, so it says, the code section says mandatory minimums, and so it strikes the language mandatory. So it still leaves minimum sentences for drug trafficking crimes. And then at the end of the bill, what it says is the judge shall impose a minimum sentence unless there's a manifest injustice or for the protection of the people. And then really that's what it does, is just, it doesn't get rid of mandatory minimum sentences. The minimum sentence still remains, but it gives the judge some discretion if there's a manifest injustice.
What does manifest injustice mean? Who gets to decide?
The judge. The judge does. And this is a term that exists elsewhere in code, but it really just is, it's kind of what the old Justice Powell, I know it when I see it, kind of Stanford. Sure. It's, circumstances that would shock the conscience, that would be, so extreme as to be shocking. Those cases where the judge finds, gosh, I can't believe I'm having to lock away an 18-year-old first-time nonviolent offender for 10 years and ruin their life completely off of a, possession charge or things like that, where, and we don't want to be too defining of what those circumstances are, but we know that judges see those circumstances and we trust that they will identify them appropriately.
Yeah. And to be clear, this statute, it doesn't have anything to do with intent. It has everything to do with how much of the drug you're in possession of.
Right, that's all the statute does right now. It doesn't matter what the intent was, what you were doing. It just simply says if you are in possession of a certain amount of certain drugs, you're convicted of trafficking, not possession, it's actual trafficking. So.
But we're talking about large amounts of these drugs. Are there any situations in which somebody has that amount of marijuana or heroin?
Sure.
In which they're not, or they're just planning to use it?
Yeah. Absolutely. I mean, we heard a lot of instances in committee where people were in possession of amount that was for personal consumption. Now, they were heavy-duty users, and I think with heroin you build up a certain resistance, and you need to use more and more and more, and you get caught with this amount that is for your own personal use, and it triggers the mandatory minimum. In other cases, we have the instance that made the news recently of the person driving the hemp truck of industrial hemp, which my understanding is can't even get you high, but because Idaho still makes it illegal, even though it's not illegal at the federal level or in most states, because of the sheer volume involved, it requires a 5-year mandatory sentence with no possibility of parole. And as Representative Zollinger said, the judge is not allowed to look at anything other than volume. They can't look at your priors, they can't look at the circumstances, they can't look at anything other than volume.
And to be clear, this is a truck driver who lives out of state, works for an out-of-state company, and was transporting hemp plants from one state where it's legal to another state that it's legal. But wouldn't it be up to the company to know that you can't do that in Idaho?
You would think so, but I mean, who knows? It's now, who knows what their intent was, but it's now federally legal too. And so you could assume, that was a recent change in federal code, so I could see an employer obviously just making the assumption, hey, it's legal federally, we can drive across, an interstate commerce, which is what they were doing. It sounds like at this point.
And you could quibble with, whether they should have done more research, was it, a mistake was made, but it's a mistake that justifies incarcerating them for 5 years at taxpayer expense and ruining the person's life. That's an awfully high price to make for failing to do your thorough legal research to determine that we are one of only 10 states in the country where hemp is still illegal.
You had mentioned the cost to the taxpayers. We're talking about a relatively small number of people who are incarcerated because of these mandatory minimums when we're looking at the overall prison population in Idaho. So if we're looking at ways to reduce that cost, is this really the right way to do that?
Well, it's nearly 400 people, so and the cost of that incarceration is about $10 million a year. So I would say that's not insignificant. But I guess my answer to that is we need to do more than this. Before we came into session, the corrections folks were saying they needed $500 million to build larger prisons to deal with the, I think now 700 people we've had to ship to Texas, where I understand there are terrible conditions. We're number 3 in the nation on our incarceration of our citizens in terms of the percentage being incarcerated. We need to really dig into the issue even more aggressively than this. This is the most obvious low-hanging fruit, total no-brainer thing that we should be starting out with. We probably need to do 20 things on top of this, but this would be, I think, the most obvious first step of many.
I completely agree. In fact, it was the only unanimous recommendation coming from the JRI subcommittee this summer. So it's the low-hanging fruit. It's the first step. But it's a step in the right direction to start getting to the larger problem of prison overcrowding and get to the real issues of rehabilitation and treatment.
You know, many of our bordering states don't have mandatory minimums. Are we risking taking away an incentive for large traffickers to stay out of the state of Idaho?
I don't think so at all. The bill that we're proposing would create an escape hatch for judges, and a safety valve, if you will, where for those cases of manifest injustice, where the facts of the case make it so extreme that this shocks the conscience to send this person away for 5 years, 10 years, 15 years. It would be almost inconceivable that an out-of-state professional drug dealer who decides to pounce in Idaho would qualify for that. No judge would look at them and say, wow, you're really the case that tears at my heartstrings and really makes me want to deviate from the sentencing scheme. So it would, this bill would do them no good whatsoever. So I think there's that, but beyond that, I think your average user and most of the people we hear from who are locked up on these, it's not El Chapo, and it's not Walter White or whatever. It's some dumb kid or a young addict or maybe a middle-aged addict, but they didn't even know. None of the folks we talked to even knew there were mandatory minimums on the book. These are not folks who are perusing our criminal codes and doing a careful analysis of where and when they want to offend. And if they are those people, as I said, they certainly are not going to be qualifying. If they're that kind of cold-blooded, calculating professional drug dealer, it's inconceivable that they would qualify for that manifest injustice exception.
Right. And it should be noted that the word minimum sentence is still going to be in the statute. So unless you're an attorney or very astute at reading the code, any normal person is going to still read that code section and say, oh, there's a minimum sentence of this for doing this. Just deleting the word mandatory, your common user is not going to comprehend the difference in mandatory minimum or just a minimum sentence.
I think that's exactly right.
But the common dealer might if they're out of state. And when we're dealing with an opioid crisis like Idaho is and like so many other states are, is now really the time to move what may be an incentive for some of these large-scale dealers to stay out of Idaho.
I don't really believe that the common dealer is going to see a difference because this change wouldn't affect the consequence for the common dealer. The judge is still going to be required to give that common dealer the minimum sentence that's still listed in the code section. It only gives, again, he's going to have the discretion to say, oh, this is a dealer. I'm going to give him the minimum. In fact, he's required to give the dealer the normal minimum sentence. He has the option, if it's not a dealer, one of these individual user or something, then he has the discretion. But if it's a dealer, it's not going to affect him differently. And a dealer is going to know that. If these dealers are as smart as the prosecutors and the police say, they're going to know, I'm still going to get the minimum sentence because I am trafficking.
And actually, they'll probably get a lot more than the minimum.
Right.
When we heard from a judge on this, they said, with the really bad guys, we don't stop at the minimum. We go way above the minimum. We're happy to go.
The minimum isn't just a ceiling either.
It's not a
Right.
ceiling. They can go far in excess of the minimum, and they are happy and eager to do that when they see somebody who really does need to be locked up for a long time.
Another thing I'm curious about, across the nation, we see racial disparities in sentencing when it comes to both prosecutorial and judicial discretion. If we take away that mandatory minimum and we give more flexibility to the judges, are we risking making that racial disparity wider in Idaho, especially as we're becoming more diverse as a state?
I don't think so at all. I think currently there is discretion in the system, but the discretion belongs entirely to the prosecutors. The prosecutors have all the power currently to decide what charge they want to bring, and the judge has no power because then once that charge is brought, they have lost all sentencing discretion. So insofar as we're concerned that discretion would be used in a racially discriminatory way, that risk is fully out there. The prosecutors have every ability right now to, and I hope they're not, and I don't have a reason to think they are, but if there's a risk, that risk is fully out there right now. And I don't think we would be changing that risk by giving judges discretion. In fact, I think judges are really the far more appropriate person in the system. In an adversarial system, I think it's far more appropriate for the judge to have the discretion and the power than for the prosecutor, who's sort of a partisan player in this system, to have all that power. But beyond that, there is a system called Odyssey that the judges adhere to that gives them all the information on the norms in sentencing and what the average sentences are, and they tend to want to stick to that. So I think that it won't really open the door to an explosion of any sort of discriminatory sentencing.
And I also think it actually could help because, it may be not racial, but as far as income inequality, the prosecutors right now can make the decision. If somebody can't afford an attorney, they're going to be scared to death of this mandatory minimum sentence and plead to some other deal. Whereas if there's somebody that can afford an attorney, they're going to be able to come in and say, the attorney will counsel them that this really isn't going to be on the table based on these circumstances. And so I think by doing this, it actually could fix some income inequalities that are built in when the prosecutor's making the decision. When it's the judge has all of those factors to consider, and they've had an opportunity to be heard if they're to the stage that they're before a judge. So I think in reality, this could actually help some of the inequalities built into the system.
And it would allow, I've heard of cases both from attorneys and from folks that I know that are on the receiving end of these. There are folks who could actually try to assert their innocence, but they don't dare try because there's such a hammer being held over their head with this mandatory minimum that they just plead because it's too risky to go to trial and try to defend yourself. And if they don't believe your defense, then there's no option, there's no out. You have this mandatory minimum no matter what. So even people that could really assert a viable defense to absolute innocence end up pleading. And I think Representative Zollinger is probably right that phenomenon probably comes into effect more often in more vulnerable, low-income populations.
This isn't the first time that you've brought this forward. Last year it stalled in the Senate after passing the House. What's different this year?
A lot of things have happened since last year. And actually, I wouldn't say it stalled. I think what happened was the chairwoman at that time wanted to hold an informational hearing and learn more about it before allowing a vote. So it was actually never voted on in the Senate last year, but it passed the House with a supermajority. And every time a group has had a chance to really fully hear the issue and hear all the testimony, it has passed commandingly. So we just need to make sure we actually have that opportunity to get our folks to testify. But since that time, as Representative Zollinger mentioned, there was the Justice Reinvestment Commission that addressed it and decided unanimously to recommend that we move in this direction. We had a long discussion in the Criminal Justice Commission, where I think a lot of these issues were fleshed out. We had federal legislation passed, which was remarkable. It's the only bipartisan thing, basically, that's happened in this highly charged atmosphere, where we had this massive wave. I think it was 87 to 13 or something when this very similar legislation was passed at the federal level. We've also heard some numbers that are pretty sobering in terms of the $500 million number for prisons, the fact that we're third in the nation, and there's, I think, a building pressure to really address our over-incarceration problem. So I think actually we were in good shape to get it passed last year, and I think we should be in even better shape to tell our story this year.
Last year, your co-sponsor was Representative Christy Perry. This year, you've signed on. I'm curious, you two are from different parties. Do you have different ideological reasons for arriving at this bill?
In our discussions, I don't think so. I think we agree, that the purpose should be to incarcerate those people that are a danger to society. Those people are not a danger, that we should be helping them become productive members of society. And, I think our parties, this is one area, like she said, the federal law that passed. You had people from all spectrums coming together to pass that reform. And I think that's a feeling this year in the Capitol, at least in the House, that, we all want to be helping people become productive members of society. So when it comes to criminal justice reform, we're on the same page.
Absolutely. Every time I've heard Representative Zollinger speak on this, I'm just thinking, amen. So I agree 100%. And I think we both agree that the criminal justice system has numerous purposes. Deterrence is one, but I think, justice, fairness, retribution, rehabilitation, cost effectiveness, there needs to be a holistic picture. Right now we're throwing everything under the bus in the name of deterrence. And actually, I don't think there's really any case to be made for deterrence here. But I think when you look at the holistic picture, there's no question in my mind that we should be moving in this direction. In all our conversations, I think we've been on the same page with that.
As you mentioned, this is just one piece of the judicial and corrections puzzle. Are there any other issues on which we might see you two team up?
Maybe.
There could be. There could be. We're in constant discussion about that. So we're both passionate about this subject, and so they're very nothing specific, but there very well could be.
We were on the same page previously with civil asset forfeiture reform. Yep. And actually, I would say that's where this all came from for me, because I'm an attorney, but I don't practice in criminal justice at all, so I had to come to this fresh. But I was working on civil asset forfeiture reform a couple of years ago, and I was talking to judges, and I was talking to attorneys and saying, am I on the right track here? Is this something I should be doing? What do you think? And they all said, oh yeah, absolutely, you should fix that. But let me tell you, the number one source of injustice in our system, the main thing that needs to be fixed is mandatory minimum sentences for trafficking. And I heard that from a few sources and and thought, okay, maybe I should look into that. But we were together on that, and I know we're having some discussions maybe about trying to clean people's records up a little so they can move forward in the world and get jobs.
We are.
Any news you want to break right now? Or?
It's still in draft form.
Okay, all right.
Discussion draft form.
All right. Well, Representative Alana Rubel, Representative Brian Zollinger, thank you so much for your time.
Thanks for having us.
Thank you.